Appreciate that. Good afternoon and welcome to the Court of Appeals. I'd like to introduce the panel and staff here this afternoon. To my right is Judge Jeff Carpenter. To my left is Judge Jefferson Griffin. My name is John Tyson. Our clerk today is Mr. Eddie Saunders, and our marshal for the court is our Richard Remilliard. We have one case on the docket today, Plec versus Pham. Are there any preliminary matters to come before the court?
I do not believe so, Your Honor.
Okay, all right. In that case, then, we will hear from the appellant. Good afternoon.
Good afternoon. Thank you, Your Honor. May it please the court, Brett Holiday here on behalf of Mr. James Plec. Your Honor, I'd like to reserve 5 minutes at the end of my time for rebuttal, if I may. The parties in this situation were in a long-term relationship in Australia that was not a marriage before they moved to the United States. While they were in Australia, they both had substantial assets, totaling around $1 million or more in approximate assets, both of the parties individually. While in Australia, my client, Mr. Plec, came to Ms. Pham and asked her for some money to purchase a home in Georgia in the United States. She agreed and gave him money in Australian dollars. They calculated the interest on the line of credit which she drew the money from in Australian dollars. He repaid her in Australian dollars, an entirely Australian dollar transaction. Thereafter, the parties decided to immigrate to the United States with their son born to their relationship.
So the $4,000 in change in interest, that's expressed in Australian dollars, not U.S. dollars, correct?
That is our contention, Your Honor. And if you look at the record, you'll see that the loan calculations were made by Ms. Pham herself, saying this is the interest I am being charged by the Australian bank, and therefore the amounts were in Australian dollars. Thereafter making this loan, the parties decided to immigrate to the United States with their minor son. Their minor son is a U.S. citizen, and so no application was needed for him to move to the United States being a United citizen. However,
your client has dual citizenship.
I'm sorry.
Your client has dual citizenship.
Correct, Your Honor. My client has dual Australian and U.S. citizenship. Ms. Pham, the defendant, has New Zealand and Australian citizenship. And so because of that, my client filed what is known as an I-864 affidavit telling the federal government that if Ms. Pham came here, he would not let her become a public charge. But of course, that was not necessary for his U.S. citizen son. The parties thereafter moved to the United States, married, shortly separated, and a lawsuit ensued, which brings us here today. I think it's important to note at the outset that the parties share equal custody of their son by agreement. There was a hearing in this matter in December of 2019, and that was for equitable distribution, unjust enrichment, and a breach of that affidavit. Now, I think it's important to point out that at the outset of that hearing, Ms. Pham dismissed her claims for child support and spousal support at that time. The trial judge in this matter, Judge Mann, issued a ruling via email in October 2020. Thereafter, the parties had a conference in February of 2021, and an order was entered in June of 2021, almost 2 years after the hearing in this matter. Our first point of contention with the trial court's order is that it is our position that the judge inappropriately calculated a household size of household size of 2 as opposed to a household size of 1 when determining Mr. Plec's liability under the affidavit of support.
Let me ask you this. How should this court review the trial judge's decision? Under what standard?
I believe this would be an error of law, Your Honor, and therefore, because of that, we believe this is a de novo review, and it would be our position that the judge made an error of law in reaching this conclusion.
Generally, would you agree that when the trial judge is calculating expenses and et cetera, that there's an amount of discretion that the trial judge has in making those decisions?
Absolutely, Your Honor. I think the judge gets some discretion in how they calculate those sorts of things, but we believe this is different because this is an issue where it would be our position that federal statutes are at play and that there is a violation of a federal statute, hence the error of law. And so it would be our position that it should have been a household size of 1 rather than 2. And when you look to the law on this issue, what you'll find in the federal statutes and code is that there's plenty of law on how we complete these financial or these affidavits for the sponsors, but a complete lack of law in the statutes and federal regulations on how to enforce them. And there's, of course, very different considerations for the federal government there. When we're talking about completing a financial or an affidavit of support, the federal government is concerned at that point, is this sponsor going to be able to pay the bills considering their other needs and expenses, hence their dependents? Whereas when we're talking about enforcing an affidavit, we're looking at a very different situation here, which is this potential immigrant subject to become a public charge if they do not receive enough support? And if you look at 8 U.S.C. 1183A, you'll see that that specifically deals with the requirements for a sponsor's affidavit of support. It's in the title. If you look at the Code of Federal Regulations, 8 CFCR 213A.1, it does define a household size in that section, but it says at the very beginning of it, as used in this part. And of course, when you look at the rest of that federal regulation, you see that that part is dealing almost entirely with how the agency should review a sponsor's affidavit of support. So our position would be that there is a lack of definition in the federal statute for this necessary part of the claim, and because of that, we would look to Martin in our cases that says that where we're lacking a definition that is necessary, we should look to statutory purpose. And here, I think it's unquestioned that the statutory purpose in the congressional record was to prevent immigrants from becoming a public charge upon arriving here. And to give the court some instruction on this point, we've presented the Tour Davis case. And in the Tour Davis case, there were similar facts as to here. And in that case, a district court in Maryland said, look, the children should not be considered part of the household size because these children were not the intended beneficiaries of this affidavit. It was the wife in that case. And the children were U.S. citizens in that case, and therefore the laws of the state of Maryland could provide for their child support. As in Erler...
Would you agree that a custodial parent of a child will incur greater expenses beyond the support of the child than a single parent?
That the custodial parent would than a single? I think that they would have, I may be misunderstanding the question, but I would think that they would have relatively equal expenses here, having equal custody, but I might have misunderstood, Your Honor.
Well, I think that the child is with both parents equally 1 week and then 1 week. I saw that in the record, I believe, right?
Yes, Your Honor. They share equal custody.
So in terms of going to school or buying trips or whatever, is it your assertion that each parent is bearing an equal amount of expense for the child?
I would say roughly so, yes, Your Honor. That would be our position, is that they're both bearing...
So to and from ball games, to and from school, to and from plays, to and from friends' birthday parties?
Yes, Your Honor. From what we have in the record, I think that's all I can say is that, yes, from the record, that they should ostensibly be sharing equal support of their minor child. So
neither one of them would have expenses out of their own pocket necessarily different from the other? Is that your argument?
That would typically be my position, although, as is common in some child support cases, it may be possible one parent incurs more expenses than the other. But in this case, that wasn't even at issue because the child support claim was, of course, dismissed at the beginning of the trial. So the court didn't even have evidence in the record, I don't believe, on that point. And so we've also cited to the case of Erler, and that's out of the 9th District. And in that case, the 9th District similarly found that where only one person is being sponsored, there should really only be a household size of 1 because the affidavit was really only intended to prevent that person from becoming a public charge. Now, the defendant does point out that this case is distinguishable in the fact that in that case, the wife had moved in with her adult son, and of course there was no way that the sponsor could have envisioned that he'd be supporting not only his wife, but the adult son of her. However, what the court focuses on that case is the reasonable expectations of the parties. And the fact is the reasonable expectation of my client, Mr. Plec, was that, of course, he would be supporting his wife through this affidavit of support, or his future wife at the time, but not in any in any realm would he imagine that a federal immigration law would define his rights as a parent. You know, going into this, I think anyone would expect that this is the province of the state. And, you know, if he's going to be...
So you mean his rights as a parent? What do you mean by that?
I might have misspoke, but what I meant is that the state would define the contours with its child support laws as to what his obligations are as a parent when it comes to child support, not federal law.
Not foreseeable for him that if they had a child, he would be, by signing that affidavit, that he would be in charge of that child as well?
I think it's foreseeable to him that he needs to support his child, and of course he would want to support his child. I think what is not foreseeable to him is that the parameters of that support would be defined by federal statute as opposed to a state statute on child support. And, you know, it would be our position that it would be an overreach, essentially, to let the federal statute define state matters here. And the fact is that children's needs are different in every state of this country, and a one-size-fits-all federal poverty guideline might not address the needs.
But don't you take on that risk if you're immigrating under these circumstances? I mean, you could go naturalized and everybody's straight on, you know, wherever they live, whatever the state jurisdiction is, but I mean, isn't that part of the, you sign up to come in that way?
I agree, Your Honor. He has, without a doubt, a duty to support his minor child. And he's taking on the risk of saying he's going to support his wife here, though. But I think that, you know, the expectation of someone entering into this is that that duty would be defined by state law. And here, it could have been defined by state law had Ms. Pham proceeded on her child support claim at the trial level. I think it's important to point out that the defendant says that we are trying to read in a definition to the statute. And in doing so, what they cite to is the cases of Liu and Zhu. And in those cases, the courts have said, we're not going to read in a duty to mitigate for an immigrant in these cases because that's a common law contract offense, and this is very much a statutory creature. And of course, that's different than what we're dealing with here. Here we're saying the federal government has failed to give the courts in this state the necessary tools to resolve the disputes they've been told to resolve. And so where no definition exists, something is necessary to step into the void.
Well, let me ask you this. Wouldn't a better argument, and I'm not trying to frame your argument, wouldn't a better argument be the child is a United States citizen?
Well,
and the duty of the father, the residence of the child is the residence of the parent, and therefore the obligation would arise under state law and not federal law? Isn't that a better argument than you're trying to make?
I think that's essentially what we're trying to say, and why I pointed out that it was a U.S. citizen child, and yes.
So there'd be a difference if this was the wife's child, for example, and they brought them both. What difference would that make if this had been a minor child of the wife?
I think it would depend, Your Honor, from our position as to whether the sponsor was sponsoring that child. And if they were sponsoring the child, as it sounds like they would in that situation, then yes, there would be a reasonable expectation that you'd sponsor the child. But even if they weren't, I don't know how a situation would arise where they wouldn't be sponsoring the child. But I think at that point, yes, there would be maybe some reasonable expectation, but of course that is...
With the child's a United States citizen, they would need no basis for that child to come into the country with the father. Is that correct?
Correct. You wouldn't
The child would travel basically on the father's passport, correct?
Correct, Your Honor. And so the child is free to come and go as they please into the United States here. And so the affidavit should and only deals with the support of the immigrant in these situations, of which the child was not. And so it would be our position that the household size should be limited to one in this situation.
But you're not saying he does not have support obligations to the child?
Not at all, Your Honor. I think that is defined by North Carolina law in regards to child support. And the court had jurisdiction to hear that, but Ms. Pham dismissed that claim at the outset of this case. And so it would be our position that it shouldn't be an end-around use of federal immigration law to get to a result that was the province of the state when it comes to child support. As far as the income, it's It's our position that the federal statutes and federal regulations are again silent on this issue. It was our position that the judge failed to consider phantom depreciation expenses when she was calculating the adjusted gross income. And the reason we think that that matters is because, you know, while you may properly say in your taxes, I had this expense and take this deduction, the money is still in your pocket. And so when we're looking to figure out how much income you have, we should properly look at that money as we do in other areas.
All right, let's go back and how does this court review that decision?
I believe, Your Honor, it'd be our position that this is an error of law as well, because we believe that the judge violated the intent of the immigration law at issue here, and we believe because it is an error of law, this is a de novo review as to the judge's findings on this point.
What determinations of income and characterizing income by the trial judge in a domestic case is normally there's a great deal of discretion according to the trial judge, right?
I agree with that, Your Honor, but we also have a established law that they still have to abide by in that situation, whereas here, we are admittedly in somewhat of a vacuum would be our position, and so this is, our position is a new frontier, and within that frontier, we're asking this court to consider the fact that certain expenses such as depreciation aren't really expenses and should be included as someone's income as we have in child support cases in this state.
Wouldn't the IRS rules on the proper way of taking depreciation be a guide for us on that, or a guide for the trial judge?
I think they can, Your Honor, and I think what's important, though, is in this case, there was a qualified accountant who testified as to how those rules apply in this case. And that qualified accountant testified to the fact that they added back in the income or the depreciation expenses into the income to properly arrive at the defendant's cash flow. Now, the defendant says that, you know, under federal law, it could have been for actual expenses. But the reality is there's nothing in the trial record that actually goes to that point. And the further reality is that the only questioning of the CPA on that point was purely hypothetical by the defendant at that time.
Why wouldn't that be a credibility determination by the trial court?
Well, the trial court has not given us any indication that she does not find, I believe, the accountant to be uncredible in this case. And so,
But the trial court would be free to accept whatever portions of testimony that she felt she would not be able to take all or none, would she?
correct. I mean, I think the trial court has that discretion, but what we're saying is when you're trying to determine whether someone has breached a contract, and part of that determination is if you've breached it, does the person have income which meets this level, you should really be considering the whole picture. And we feel the federal statutes fail to do that. I think we both agree, both defendant counsel and I agree that the United States Code doesn't define it. The Code for Federal Regulations, you know, it does have a part that speaks to income, but again, that is included in a part that is entirely dealing with the sponsor's affidavits. And when you look at that definition, it says, it talks about how a tax return shall be filed with an affidavit of support, which implies that what we're talking about here is completing an affidavit, not enforcing an affidavit. The defendant cites to a line of cases that seem to stand for the proposition that the federal regulations do step in this situation, but it would be our opinion that those cases are not binding on this court because they do not properly cite that part of the federal regulations. And in fact, if you look at the Love case cited by the defendant, even in a footnote in that case, they recognize that there is no federal definition when it comes to enforcing. And so in regards to the Chevron argument that they make an argument that essentially says, look, the federal agencies have spoken here, and we should be giving deference to that decision. But I think what's important to point out is what we're saying is the agency just hasn't spoken at all when it comes to enforcing affidavits. And the Chevron court recognized that in that vacuum, the courts can and must step in to fill the void where the executive and the legislator have failed to do their job. As for the subject matter jurisdiction arguments, Your Honor, it would be our position that these claims past 2017 for breach were not ripe. The essential logic of that is that the breaches had not occurred yet, so you could not possibly have alleged something that was speculative at that point. I do see the Souzo case that was cited by the defendant in a recent memorandum of additional authority, but that case was very different than here. That case was dealing with a situation in which there was a known contract, a known ability, a known requirement to pay a monthly amount of support, whereas here you can only judge the liability on a yearly basis, and there are a lot more moving pieces. Has the immigrant provided enough support or gotten enough support on their own? Has the sponsor provided enough support? There are a lot more moving pieces. And as to the argument that it would relate back, even if it relates back to conform to the evidence, the allegations on the later breaches, it seems like a logical fallacy. You can't allege back at that time in 2016 that breaches occurred in 17, 18, and later. As for the money that this judgment was made for unjust enrichment, we believe the judge committed an error of law by determining that the judgment should be issued in US dollars as opposed to Australian dollars. When you look at the North Carolina Foreign Money Claims Act, North Carolina NCGS 1C 1826A says that if a foreign money claim is made, the judgment should be made out in that foreign money. And here, I think what the defendant says is, we didn't make a foreign money claim. What we did is we made a claim for unjust enrichment. But my interpretation of the statute is that the statute isn't making its own set of claims here. It's just defining other claims for relief that already exist under North Carolina law. When you look at the Foreign Money Claims Act, 1C 1820, subpart 6, it says that a foreign money claim is a claim upon an obligation to pay or a claim for recovery of loss expressed and or measured in foreign money, which is what we had here, a claim made in Australian dollars. 1C-1821 then says that this act applies to foreign money issues even if other law under the conflicts of law rules of this state apply. And so what I think the act is telling us there is the act isn't necessarily creating its own new set of claims, it's defining other forms of relief that already exist in this state.
To accept your argument, wouldn't that be place all the exchange rate risk on the creditor?
I think it places it on both parties, and the chips fall where they may, Your Honor, because it could go one way, depending on how the exchange rates go. It could go the other way. And admittedly, in this case, it would put that burden on the defendant in this case, but it could have easily have gone the other way, and the record reflects that the U.S.-Australian exchange rate has been up and down over the years. And it makes sense. You think if you go to a bank and borrow U.S. dollars, the bank expects you to pay U.S. dollars back, not another currency. And that's what we're essentially saying here. The reality is that they dealt solely in Australian dollars except for when he converted the money to U.S. dollars to purchase the property. And the Foreign Money Claims Act says that therefore should be a foreign money claim for Australian dollars. She indeed made a claim for Australian dollars, and it'd be our position, therefore, that the court was required as a matter of law to order the judgment in Australian dollars. As for the breach of contract issue, our position is that there was essentially an implied in fact contract here, and therefore the court made a reversible error by finding unjust enrichment. The Lake Toxaway case recognized a situation in which a homeowners association provided benefits to landowners. Those landowners received those benefits, and therefore there was an implied offer and acceptance and thus an implied contract. We know from the Water's Edge case that if there's an implied contract, we cannot have a claim for unjust enrichment. The party needs to sue under the contract itself. And in here, we had a clear offer and acceptance. We had a request for a loan, a giving of the money, and a repayment at some point on those terms. Now, it is true that that is not a completely filled out contract, as the defendant rightly points out. There are missing terms, but our cases have said that the court may imply terms in those situations. And since this should have been an implied in fact contract, it should have in fact been a claim for implied contract, breach of implied contract, not unjust enrichment. And I don't disagree with the defendant's arguments that Pharma and Robertson dictate that if it's an unjust enrichment case, we look to North Carolina General Statute 24.5b for interest calculation. But of course, our position is that this is not an unjust enrichment case. The Curry and Rue cases cited by the defendant in support of their claim that this is an unjust enrichment case are distinguishable from here because those dealt with situations in which the trial court had no other tools. They didn't have the ability to find an implied contract, and had they not, a gross injustice would have resulted in those cases. As for the weighing of evidence, we believe the court abused, if your honors disagree with that prior claim, we believe that the court abused its discretion when it ordered the unjust enrichment award by not providing any weight to my client. He provided considerable allegations and statements as to the sweat equity he put into the home, the rent he paid to the home, the contributions to the marriage, and despite the parties' similar financial footing, was not provided any equitable consideration. I think the defendant says that she just didn't, the trial judge did not agree with my client, but the reality is there's nothing in the record that shows that. As far as the submission of the order, I'm not going to sit here and tell your honors that I think that an order, isn't entered until it's in writing, until it's signed. I agree with that fact, and I agree that a judge can change their mind between a ruling and an order. But that's not what we're challenging here. What we're challenging here is the way in which this order was submitted and the way in which changes were made without the opportunity for argument. I'll let my brief speak for itself when it comes to the prejudice arguments, although I will highlight to the court that nearly 2 years passed between the parties having this trial and them completing their narrations. As far as our last claim for relief, our last argument is the attorney's fees argument, and what I'd point out there is that it is our position that the attorney's fees award here should also be reversed because it'd be our position that the breach never occurred on the affidavit of support. And in support of that, we've provided, your honors, the Ian Zanelli case, which says when you look at 8 U.S.C. 1183A subpart C, it talks about attorney's fees for these affidavit of support claims in the context of collecting on those claims. And so that language should mean to the court that you should only be able to collect on attorney's fees in these situations when you've actually prevailed on the underlying relief. For those reasons stated, your honor, we would ask that you would reverse and remand, and if the court does not have any other questions for me, I will reserve the remainder of my time.
Thank you. Thank you, sir. Hear from the appellee. Yes. You may proceed.
Thank you, Your Honor. May it please the court, John Boutwell, and I represent Monica Pham. I think it's important as we start off to go back in time to the context, very briefly, to set the stage for the two legal arguments, which are the affidavit of support issue and the unjust enrichment loan.
I had one question,
Yes, sir.
threshold question. There was a 2-year delay between the hearing and when the order was entered, is that correct?
Yes, sir.
Was there a big swing or change in the exchange rate during that period of time? I guess my question was, would the husband have been prejudiced by a change in the exchange rate between the entry of the order and the date the hearing was heard?
So I don't think there's anything in the record on what the exchange rate was at the time the order was entered. What my memory is that in the transcript is that at the transfer of funds to Mr. Plec, I think the exchange rate was like in the 0.90% range, and then at
The trial court used the exchange rate on the day the loan was made?
Yes, sir.
Okay.
Yes, sir.
Thank you.
And then at the time of trial, it had dipped to like 0.6, it was like 68 or something like that. And the trial court heard that argument. And by the way, and recognized that this would be a windfall for Mr. Plec if we were to use this argument, this novel argument brought up on the last day of trial about the North Carolina Foreign Money Claims Act. So while they were in Australia, Your Honor, Mr. Plec wanted Ms. Pham to come to the United States. And as Mr. Halliday said, they did have a son together over there. They had a relationship. While they were in Australia, she was reluctant. That's what the transcripts and the record shows you. She didn't necessarily want to come to the United States. He made a couple of promises to her that's at the heart of these legal issues in front of your honors. And one of those was he was in the process of buying not one, but a second home in Georgia. They had a home he was in the process of buying a home in Charlotte. He wanted a second home in Georgia. he approached her and says, I'd like to borrow money. This is what I want to do. She loved him. She trusted him. And so she took out against her line of credit and gave him 110 Australian dollars at that time in 2013. He promised to pay her back. That was promise number one. Promise number two was...
And then in the trial court's order, the repayment's like 102,000 US dollars.
Yes, sir, Your Honor.
Which reflects the exchange rate at that time.
That's right. That's right. And giving him credit for interest payments that he made. And promise number two was the affidavit of support that he signed with the U.S. government, that if he brought her over here as an immigrant, that he would sponsor her. And at the time he made those promises, the record shows that he filled out not one, but two affidavits of support. One's the I-134, the second's the I-864. And if you look at those documents, he's representing to the U.S. government that he's making over $160,000, he's got over $1 million in assets, and he's going to fully support Ms. Pham.
Now, your client did go to work.
She was working in Australia, and when she moved to the United States, she had to resign that job.
But she did acquire work here in the United States.
Eventually, yes, sir. It took her a while, given her immigration status. She eventually got part-time work, and then in 2019, she was able to pick up full-time work.
What was her status when she entered the country?
She was on immigrant visa, and she went through a process that was eventually, after separation, finalized. And so...
Well, before we go there, did she get permanent resident status upon marriage?
Afterwards, yes, yes.
Was that the triggering event that gave her that?
I believe so, Your Honor, I believe so. I don't recall those facts being contested heavily at trial, but I think so.
And then what changed after the separation or after divorce? Did she get some additional or further status, or what?
I think my recollection of the timeline is in between separation and the divorce, her status was completed with the U.S. government at that time. So I don't...
Basically, it was a green card, then she was permanent resident.
Yes, sir. That's my understanding. And so what's interesting, Your Honor, is that once they moved here with their son, not only did he not fulfill those obligations, those promises, the loan, payback, and the affidavit of support, but he flipped the tables and required her to support him. And so that's like a double whammy. So not only is he not supporting her, the evidence shows that he created a family budget, and he was requiring her, the immigrant, to provide $21,000 annually to the family support while they were living there. Totally contravenes what he promised he was going to do. So against that backdrop, we have these legal issues of the affidavit of support issue and the loan issue.
Let me ask you, I asked your counsel on the other side the question, if the child was a United States citizen, and generally residence follows the parent, and which means the minor child would have been a quote-unquote North Carolina resident. Why wouldn't North Carolina law in determination level of child support be controlling as it relates to a resident, a citizen, who is following the residency of the parent?
Right. And I think my position on that, Your Honor, would be if you have that specific situation, then yes, you would have state statute control the level of support between the parents, the biological.
Wouldn't that negate any support obligation under the I-form, and basically his obligation to support his child would be determined under state law?
I think, but I think it may be a little bit more nuanced than that, because here what you have, so here to me is the nuance of the household size argument.
But the child was not named in the affidavit, correct?
He was not named in the I-864. He was named in the earlier affidavit. And that's what, to me, makes this thing a little bit more interesting, Your Honor. So what happened was, and this is on exhibit pages 313 to 314, Mr. Plec filled out an I-134 affidavit of support, the thing he has to fill out before the I-864. And in that setup document, he listed their son as being, he checked the box partially dependent on him, not wholly. It's wholly dependent, partially dependent. He checked partially dependent. And then this is what he did next. He did this in January of 2014, as when he signed that I-34 affidavit of support. And in that, he stated he previously submitted an affidavit of support for his son on May 2nd, 2013. So here you have the sponsor who's sponsoring Ms. Pham, and in that first set of documents for the U.S. government, he's saying under oath, he signed this under oath, that he had already submitted an affidavit of support for his son. That's where I think this gets interesting on the household size too, because if you agree with Mr. Pelk's argument, and that I think his argument follows Erler, the Ninth Circuit case, that it's based on who the sponsor sponsored, and it's based on reasonable expectations. If you go there, if we go there, because there's not a lot of cases other than Erler, maybe Tor Davis, that define household size, then I think the trial court got it right, that you had Ms. Pham who was being sponsored, that's household size 1. You've got a son who's dependent on both of them, and that Mr. Pelk uncontrovertedly signed this earlier affidavit saying he had previously submitted an affidavit for his son. And that's where the facts stop on that in our record as far as what he submitted for his son. And so Erler would suggest we go there for household size of 2, if we're following Erler here. The other scenario is if we don't follow Erler and we follow what we think the statute and regulations are, they only have one set of definitions. And they talk about 2 scenarios. One, qualifying the sponsor on the front end, enforcement on the second end. And they recognize both of those things in the statute and regulation, but they only have one set of definitions.
All right, let me go back to my earlier question. If Mr. Pelk wanted to bring the son to the United States, who's a United States citizen, would he have been required to sign anything?
To my knowledge, no.
Okay, so if he was not required to sign anything and his support obligations would arise based on his state of residence, which is North Carolina,
Right.
then why would a affidavit signed for a person he was sponsoring, who was not his wife at the time, correct?
Right, that's correct.
So there was no familial relationship. Are you making a claim there was a common law marriage that occurred in Australia before they came here?
So original counsel for Ms. Pham did indeed make that claim earlier in the litigation.
So is it your position today that the parties were married when they came here?
No, they were not married until they got here. They were not technically married until they got here.
So in order for her to come here as a resident alien, someone would have to take responsibility for support,
That's right.
but would not have to do that for a natural child of a U.S. citizen.
That's right. That's right.
Okay, doesn't that undercut your argument?
It does. It absolutely does. But here we get the hook, right? We got the nuance here of that for some reason he filed this form saying that he had already submitted an affidavit of support for his son. And here we also have
Why
this,
wouldn't that obligation arise under state law?
I'm sorry, what?
That he's recognizing a duty to support that he already has by virtue of being the natural parent.
Right.
Why wouldn't the state support guidelines control what that obligation would be?
I think that if he had not filled out that earlier affidavit the way he did, that might be a different situation and would probably be as Your Honor is suggesting. But here he did fill out that earlier affidavit under oath stating that he had already submitted an affidavit of support for a son, and that's a distinct, separate, over and above support obligation other than the state child support obligation.
Does the status of the supported change any of the obligations under the 864?
Does the status of support change?
Or the status of the supported, like if your client became an American citizen, does that end the obligation of support for the supporting person?
No, no. So the I-64 has in its form, there was several terminating factors, and it clearly says that like divorce doesn't end the obligation of support. It has talks about so many qualifying quarters, I think, of work, and none of those. That was never an issue at this trial. As far as there was no issue that he had a termination event. There was nothing like that going on in this case. So we also have their argument, Your Honors, that about the income level. And here,
So state your position before we move on from this issue. Your position would be that his support obligation was set by the affidavit under federal law and not under state law. Is
that's correct, Your Honor.
is that basically where you are?
That's absolutely right.
So as we move on to determining whether or not depreciation
Yes.
is phantom income or not.
That's right, that's right. And so here's where opposing counsel and I disagree. So the record, so if we just go straight to the record, forget some of the legal arguments. At trial, Ms. Pham put on evidence, uncontroverted evidence, that she had torn down, completely demolished, and rebuilt an Australian residence. And she also introduced receipts. So that testimony is found on pages 205 and 206 of the transcript. She also introduced receipts for some of that rebuild project, and that's on your exhibit pages 684 to 699. So a suggestion by Mr. Pelk that there was nothing in the record to show actual expenses is completely wrong. And so there was evidence of that. And the trial court heard that. And the trial court, in the trial court's discretion, agreed that the IRS approved taking a depreciation expense for my client. She wasn't going to add that back into her income for purposes of calculating the sponsor's duty of support. And so she heard that evidence. As Mr. Pelk had an expert, a CPA expert, come and testify, and she acknowledged that the IRS allows these depreciation expenses. We all know that. The disagreement is somehow Mr. Pelk thinks that this is somehow phantom, and it's not. It reflected actual cash flow expenses she made earlier in time, and she's now taken it on her tax returns. The judge heard that and decided, I'm going to use her adjusted gross income, and that was within the trial court's discretion. It also is on all fours with how these cases are interpreting the regulations definition of income. So we cited to the Pennsylvania case of Love v. Love, and it explained that the regulations define income narrowly for the sponsored immigrant. We cited to the Alaska case of Villars, who looked at what the IRS regulations allow, which is gross income minus deductions. And Villars held that earned income tax credit does not equal income for the immigrant. We cited two federal district court cases, one out of Texas, Sultana, which again looked at the regulations definition of income and said shelter is not income. We also lastly cited to Fuquita, which is the federal district court of Minnesota, which held that the immigrant's income means her federal taxable income. So all those cases, Your Honors, are interpreting the regulations definition of income. It only has one definition for qualifying the sponsor or for enforcement purposes, and they construed that that definition of income means adjustable gross income for the immigrant, and it's defined narrowly. That makes sense, because as opposing counsel said, the public policy of the statute is to benefit the immigrant, not the sponsor. And so that's in furtherance of the policy. Here's, I think, a level of frustration you may pick up on in some of the briefs is that Mr. Pelk throws out a lot of arguments to try to avoid these promises. He, in his briefs, suggested to the court that someone with assets, like Ms. Pham has assets, should not receive affidavit of support damages. That flies in the face of this court's holding in Zhu v. Dang. There's no line of cases he supports to back up that argument. He also, when he talks about income, argues, well, wait a minute, if you don't add back in her depreciation expense, she somehow is artificially depressing her income, and he likens it to a child support case. This is not a child support case. And Zhu v. Dang, Liu v. Mund, and the rest of the cases have uniformly held there's no duty to mitigate in all these cases. That's the problem we have with his income argument. Now, on the subject matter jurisdiction argument,
You would agree that generally any contract has a duty to mitigate? That's
any
general.
other contract, right, other than what this statute says, right?
So your point is that this did not arise by contract, this arose by operation of federal law?
Right. This is a special form of a contract. And some of the cases don't even allow, Your Honor's, normal contract defenses to this affidavit of support. So Mr. Plec has brought up several arguments on his appeal that were not made at the trial level. Now, understandably, you can bring up subject matter jurisdiction at any stage. I contend it's not really a subject matter jurisdiction argument. Essentially, he couches it in terms of ripeness, that Ms. Pham filed her affidavit of support claim in 2017. The trial was had in December 2019. So his argument is the trial court erred by considering damages in 17 and 18. 19, as a parenthesis, the judge didn't award any damages because she's working full-time at that point and had not filed her federal tax return, so we couldn't determine 2019. And so what's interesting is the only objection Mr. Plec made at trial was not to the subsequent years. It was to a year prior to separation. And there's a lot of objections from him about that, but never about these subsequent years. And his argument would fly in the face of the Suozo case that we submitted as additional authority. And I do think it's very similar. You had a separation agreement that was breached. Here you've got a contract affidavit of support that was breached. There you've got damages accruing from the time of trial from the time of filing up through the time of trial, and the trial court awarded those. Here you've got damages accruing from time of filing to time of trial, and the trial court here, Judge Mann, awarded those, rightfully so. Just like in that case, Ms. Pham claimed she alleged her damages would, quote, be proven at time of trial, end quote. It's record page 171. She also alleged that his obligation would continue until terminated, same page of the record. She requested the court to award monetary damages on page 177 of the record, and like in Suozo on page 178, she asked for, quote, such other and further relief, end quote.
Let's take for instance, where someone signs an affidavit of support for an immigrant. Immigrant turns out to earn multi-million dollars as a model. Mm-hmm. Would that duty to support still attach, notwithstanding the amount of assets or income that the person generated on their own?
So I would say from my perspective, Your Honor, the easy argument would be the assets based on our case law. That it's basically a cash flow scenario, not an asset scenario. Okay. But let's say income. Let's say you get an immigrant that wins the lottery or something, right?
The lottery. But that's assets, that's not income.
Yeah, well, that's true, that's right. Well, that's a bad argument. So let's say it's something where she's earning a lot of income. I think if we were to be hyper-technical, his obligation doesn't necessarily end. But if we look at what he owes, it's going to be zero because she's making income above that federal poverty guideline for that particular year.
So it
doesn't end until
you're saying it's a baseline.
That's right.
And once the baseline's exceeded, then the obligation would end?
For that particular year, he would not have an obligation. Let's say she then loses the job, and then the next year, maybe he would until it terminates by statute. Okay. That's the way I read it, Your Honor.
Mr. Boutwell, the definition that you gave earlier of the applicable income was gross minus deductions.
Yes, sir.
We've just had, you and Judge Tyson have just had a discussion in regards to it being income, not assets. Depreciation is a depreciation of assets. So how do I square income minus deductions to deductions are different than depreciation. Deductions come from your income. Depreciation is a discounting of your assets.
Right.
How do I square that with how Judge Mann handled it in this case?
Well, I think what she did is she followed those lines of cases that look at the adjusted gross income of the immigrant. And that's consistent with the regulation when it talks about how do we look at an individual's income, and in parentheses it said adjusted gross income. So the way they've done it and the way the other cases have done it is
The adjusted gross income minus deductions? That's the definition that you gave earlier when you...
right. I think
Deductions and depreciation are different.
right.
Deductions are from income.
Yeah.
Depreciation is
From assets.
discounting of assets.
Right. I think I think the thought process was, and I can't speak for other people, but I think the thought process is that once you look at the allowable deductions per the IRS, you can then arrive at that person's true income for purposes of calculating what her cash flow was that particular year. And it's not that this always makes it right, but it's an easy enough definition to follow. Like in Mr. Pelk's argument, he argues for a more expansive articulation of income, but he doesn't really tell us what we would do, almost as like a case-by-case basis. In a lot of these cases, they define income narrowly, and then they do look at income minus deductions. You also have that parentheses language in the regulation of adjusted gross income.
Would your better argument be that it may have been expressed as depreciation, but it was actually recognition of money out of pocket?
That's right.
That she spent to demolish, and therefore it was a loss of cash and not a loss of asset.
Right. You're right, and actually made that argument.
Not trying to make your argument.
No, you did a much better job than I did. That was the point we were making to the trial court in closing, that it wasn't phantom, it reflected actual cash expenses.
Was it dollar for dollar?
I don't know if that part's in the record about whether it's dollar for dollar.
You weren't involved at trial, were you?
I was not the original attorney for Ms. Pham. I came in prior to trial and did the trial.
Okay. Well, some of the earlier documents didn't reflect you being on the...
That's correct. I came in the year of trial, like halfway through that year. Your Honor, some other things that Mr. Pelk has brought up that he did not bring up at the trial level was this issue of U.S. versus Australian dollars. And in fact, this is why it's frustrating, there was a point in trial when we had a discussion with the trial judge. And Mr. Pelk's own attorney says, yes, this judgment has to be in U.S. dollars. And the court agreed with him. And so after the trial, we get to the third day of trial. So that back and forth with the trial was on transcript page 375. And so then they switch horses. The very last day of trial, his attorney goes, wait a minute, I find this North Carolina Foreign Money Claims Act, and by gosh, it has to be paid back in Australian dollars. That issue had never been litigated during the life of this case. No one pled it, no one asked for it. And so what happened, and Ms. Pham's evidence at trial, her trial exhibits asked for it in U.S. dollars. So,
But in fairness to your colleague, it was raised during trial.
It
You're saying
was.
it was late.
it was very
It
late.
was before the trial court.
That's right. And she decided in her discretion not to do it because she recognized it was going to be a windfall to Mr. Pelk to do it that way. And what's interesting is not only did her trial exhibits ask for it in U.S. dollars, they sent over a request for monetary relief before trial, and she talked about that actually she said, I don't want to misquote something, that she asked for either in U.S. or Australian dollars, whichever is most valuable to her. But at trial, it was clearly Australian dollars. And no one at trial argued, well, wait a minute, the $4,000 was paid back in Australian, and we need to convert that, and none of that ever happened in front of the trial court. And then the last day of trial was this argument, pay it back in Australian dollars. And I would point out that...
You're saying it, to apply it based on current exchange rates be a windfall to him, but isn't the way the trial court did it a windfall to your client?
Well, to me, I would say no
Well,
because,
she could take those dollars based on hypothetically a 95 cents to a dollar of US dollars and go back to Australia and pay off that line of credit based on 68 or 65. So she would get the windfall of about 30 cents on the dollar.
yeah, I guess there can be some
Her
inequity.
debt is in Australian dollars.
At that time, it was, yes, yes. And so, and this is what the trial court picked up on. She even remarked that except for the initial 24 hours or so of this transaction that happened in Australia, everything else happened in the United States. He put that money into his U.S. bank account. He bought a Georgia house. He rented the Georgia house. He sold the Georgia house. He put the proceeds from Georgia house in his U.S. bank account where they've been living, and he hasn't paid her back in the U.S., and that's where she's suffering the loss. And it's a permissive statute. If you read the statute, it doesn't say you have to make the claim in the foreign money. It says you may, and she didn't make the claim, so we don't even get there. This other thing that he brought up that wasn't brought up at trial was unjust enrichment claim versus breach of contract. His own attorney, again, told the judge he wanted this to be an unjust enrichment claim, and that was on page 474 of the transcript.
Would you at least agree that if there is a contract in law or an express contract, that unjust enrichment claims cannot arise
Right.
in the presence of a contract?
Yes. And then, if that were the case, then the judge would have awarded interest from the date of breach. But here we have an unjust enrichment claim. Everybody agreed it was an unjust enrichment claim. I even brought up to the trial judge, against my client's interest, that it's an unjust enrichment claim, so the interest can only accrue from date of filing. So he was benefited by that type of legal argument. And he wanted this legal argument so that he can argue offset, which the judge heard and denied. And this shows you what we're dealing with. His offset, he asked for offsets for immigration charges, shipping costs, so that they can come over here, which totally contravenes his affidavit of support obligation. Your Honors, I know my time's running out. He's made many
You want to
arguments.
address the attorney fees very briefly? I will
Yes, sir.
give you just a moment to do that.
Yes, sir. On the attorney's fees, so that was not, my understanding of his argument on appeal is that if his position wins and there's no affidavit of support obligation, then you can't recover attorney's fees. And I would agree with that. My ability, Ms. Pham's ability to recover attorney fees hinges on that she recovers some amount of money through affidavit of support. They don't contest the reasonableness of the fees, the judge's calculations of the fees, any of that. I think it's just this last argument that we think we went on affidavit of support. That's what Mr. Pelk's saying, and therefore there's no attorney fees.
So it's prevailing party arguments.
That's right. I think that's what he's arguing. So we would just respectfully ask, Your Honor, that you would affirm the trial court and make Mr. Pelk honor those promises he made.
Thank you, sir.
Thank you, Your Honor.
Thank you very much. Rebuttal?
Thank you, Your Honor. In regards to the contention that my client checked the box on an affidavit to say that his son was a dependent, I think it's important to point out he was required by federal law to do so. He was required to say he's a dependent because that's helping the agency determine, looking at his income and looking at his duties to his son, is he also going to be able to support his wife? And at the end of the day, it doesn't change the fact that the party that this statute was designed for was to prevent an immigrant, not a citizen child, from becoming a public charge. As for the depreciation issue, what I would point out is that there is evidence in the record as to actual expenses that Ms. Pham incurred regarding her investment property. But what our position...
On the demolition?
Correct, Your Honor. And I don't doubt that that's in the record. Our position is more so that there's not, at least that I'm aware of, evidence tying those actual expenses to the depreciation deduction or depreciation that was in the tax return. And so without that link, there wasn't anything, would be our position for the court to make that determination. As far as the cases that are cited to say that the Code of Federal Regulations do define income for this situation, I'll read those cases for you. One of them is Fukita, and the only mention of income in the whole case is of the Code of Federal Regulations is as used in the pertinent regulations, income means the sponsored immigrant's federally taxable income. And that's it. Like, that's all the analysis. Similarly, in Sultana, it says, while plaintiff receives shelter and non-financial support from her brother, that does not qualify as income, and then it cites the federal regulations, but no analysis on the federal regulations. Love, though, cited by the defendant as support that the federal regulations applies, has a footnote that says, although the definition does not specifically address what constitutes income in relations to a sponsored immigrant. So the court there is recognizing that it doesn't control. As far as the intent of the statute is still being met by considering this, what we would say is a phantom depreciation. And so, the money is still in the pocket, would be our position, and if the money is in the pocket, then that's not a risk of becoming public charge if it rises above that threshold. I think the defendant mentioned that, there was some argument as to whether we're asking the court to define income here today. It would be my position that all we're asking the court to do here today is just say, in this particular case, in this very specific situation, the depreciation should have been added back in. As far as the Foreign Money Claims Act, the reality is there's going to be a windfall if the exchange rates, go up and down in any of these cases. And so then the question has to be, well, how do we decide that windfall? And it would be our position that the legislator had said, we're not going to put that decision on a judge. We're just going to say, look, if you make a foreign money claim, the judgment should be in the foreign money. And the judge doesn't have to worry about, does the plaintiff get the windfall? Does the defendant get the windfall? Because that gets into its own separate set of issues. How does the judge decide who deserves the windfall versus the other person? And we think that's the reason, or it'd be my position, that this act takes that type of discretionary argument or consideration out of play and just makes it the chips will fall where they fall. As far as this being a permissive claim for a foreign money claim, the reality is the claim was made regardless. And it would be our position that when you make a claim in a foreign money, the act dictates that the order be in a foreign money. For those reasons stated and the reasons stated earlier, we would ask you to reverse and remand. And that's the conclusion of my argument, unless your honors have any additional questions for me.
What's up?
Okay, thank you very much.
Thank you.
Thank you, gentlemen. The case is submitted. We appreciate your good arguments and very interesting issues for the court. So we thank you for your briefs and for the efforts that you put to bring the issues before us. Ms. Clark?